Good morning or good day to everyone. And finally, we are here. Chinese law and global development. This is supposed to be a major conference originally scheduled to take place in February 2020. Now, we know that due to the global pandemic, we have to cancel the regional conference. But after much delay, thanks to the support of the Postal Dean of the UQ Law School, Professor Patrick Parkinson, and also the support of the current Dean of the UQ Law School, Professor Rick Bigwood, and the support of the Dean of the School of Law in City University, Professor Tan Zheng Han, and my colleague and co-presenter, Professor Wang Director of the Center for Chinese and Comparative Law in CTU School of Law. Now we have the conference reinstated, albeit in a downsized form. So today we are going to present a number of topics which I think would be important and stimulating to audience who are interested in Chinese law and the interaction between Chinese law and the world. So I think that after almost 2 years, we find ourselves in a somewhat changed world. Still, it is very important that we continue the dialogue between the East and the West. And today's webinar session is an attempt to initiate and continue this dialogue, this constructive dialogue. So today we have a number of renowned speakers. Some of them are my colleagues to present on some of the most important topics of relevance to today's world. So first we have Professor Nim Bin from the University of Sydney, who is going to present a topic I understand on Chinese contract law. This will be followed by a smaller presentation by myself on a similar topic about sale of goods between Hong Kong and mainland China. And then my colleague, Professor Wang Jiangyu, will talk about international topics. And then this will be followed by, again, my two other colleagues, Assistant Professor He Tianxiang and Associate Professor Wang Shucheng. And they will each present on topics about intellectual property law and also the law of religion. So without taking up too much time, I will hand the floor to Professor Nim Bin.
All right, thank you very much, Chao. It's a great pleasure to be here, and it's an honor to be on this panel with my friends and colleagues and to talk about Chinese law and global development. To facilitate my presentation, let me just first share the PowerPoint slides with you. All right, so as Professor Chao Liu has just mentioned, I will be talking about contract law in China today. So we'll be talking about Chinese law and global development. I would argue that the reform of contract law in China in the past few decades has been probably exhibit number one of law contributing to China's economic reform and international integration. Now, the reform of today's contract law in China started in the early 1990s. It culminated in the enactment of the contract law in 1999. That law was in effect for over 20 years before it was replaced by the Civil Code in 2020. Essentially, the development of the contemporary Chinese contract law has coincided with the takeoff in China's economic growth that pushed China to become the world's second largest economy in the past 2 to 3 decades. It is difficult to exactly quantify the role of Chinese law, especially contract law, in developing China's economic system. But one of the things that I thought we could look at is this World Bank ranking of ease of doing business around the world. This is a ranking that I'm sure is familiar to many people. In 2020, the most recent ranking, overall, in terms of the environment for doing business, China was ranked number 31 in the world, number 6 in East Asia and Pacific, and number 8 in upper middle income. Now, in this ranking, there's a particular parameter in relation to contracts. It is called enforcing contracts. And on this parameter, China has performed exceptionally well in 2020. China was ranked number 5 in the world and number 2 in East Asia and Pacific and upper middle income countries. Now, obviously, we all have certain skepticism about the accuracy of these rankings. But I think the fact that China performed very well in terms of enforcing contracts probably shows that China's improvement in contract law and contract enforcement has gone a long way in improving China's overall environment for doing business. Now, given the limited time that I have, I'm not going to address the contract law in most of the respects. I will be focusing on one significant aspect of Chinese contract law, which has undergone some interesting changes in recent years. I will be focusing on the interpretation of contract in Chinese law. Now, many of you would know that one of the things that has characterized China's reform of contract law is a clear and strong movement towards the respect and enforcement of party autonomy in Chinese contract law. Party autonomy has been emphasized in China's legislation as well as judicial practice in China. Now, one of the important things about enforcing party autonomy is to make sure that the intention of the parties in their contracts will be properly discovered and given effect by Chinese courts. And that ultimately is the question of how to interpret contract in China. Many of you would know that before 1999, Chinese law did not really have an established legal principle on interpretation of contract. The 1999 contract law for the first time laid down the basic approach in Chinese law to the interpretation of contracts. And that was in Article 125 of the contract law. That provision was later replaced by the Civil Code in Article 142. Now, I'm going to put these two provisions on the screen for those of you who may not be familiar with Chinese law in this respect. I will go through the current Chinese statutory provisions very quickly with you, and I'll summarize it, and then I'll talk about some of the interesting recent developments. So in Article 125 of the contract law, here we have the basic approach to contract interpretation in Chinese law. The statute, this contract law of 1999, in Article 125 says, I quote, "If there is a dispute between the parties over the understanding of a term of the contract, the true meaning of that term shall be determined in accordance with, well, this expression in accordance with in Chinese was 按照. We'll talk about the meaning of this expression a little bit later. In accordance with was, well, 5 things here. Number 1, the words and expressions used in the contract. Number 2, the related terms in the contract. Number 3, the purpose of the contract. Number 4, the usage of trade. And number 5, the principle of good faith. So that was the rule in the 1999 contract law. In the Civil Code, we now have a new rule in Article 142. The rule was essentially consistent with the old law, but with some modification. So Article 142 now reads, and I quote, with regard to the interpretation of a declaration of intention involving a counterparty, the meaning of the declaration of intention shall be determined in accordance with, so we have the same expression, 按照, but this time in accordance with only one thing, that is the words and expressions used. In light of, in Chinese, it's 结合, in light of, well, in light of 4 other things, all right? Number 1, the related terms. Number 2, the purpose and nature of the act. Number 3, usages. And number 4, the principle of good faith. So you see, these 2 statutory provisions are essentially consistent. They both enumerate 5 elements, right? 5 elements. The 2 provisions formulate these 5 elements in slightly different ways. Well, one of the questions that may be raised is that significant? In the old provisions, all those 5 provisions were referred to as things to be in accordance with. Now, in the new provision, well, you will have to be in accordance with the first element, and then in light of 结合 for other elements. Is there any difference in these 2 different formulations? Now, we'll talk about that in a moment, as I shall point out that some commentators do believe that there is difference in those slightly different formulations. But one thing that I think is quite clear here, the basic approach to contract interpretation under these 2 statutory provisions feature the following points. There are 3 points that are important here. First of all, the Chinese approach to contract interpretation is the objective approach. The law focuses on the objective elements, what the parties have written, what the parties have said, what the parties have done. The law focuses on the objective manifestation of the party's intent, not their hidden inner intention. So it's the objective approach the Chinese law has taken. Number 2, there is clearly a primacy of so-called the words and expressions. That is to say, the language of the contract. How the parties have formulated the language of the contract, that's important. In other words, Chinese law here takes the contractual language seriously. The language of the contract, the words and expressions used in the contract, they are of primary importance. They are the starting point for contract interpretation. It's quite clear that the language of the contract is very important. But the language of the contract is not the only element mentioned in Chinese law. As we have seen, Chinese law actually enumerates five interpretative elements, right? So we have gone through those 5 elements. So I've put the 5 elements here on the screen. You will see the first element, words and expressions used. Second, the related terms. Now these 2 elements I would call textual elements. These are the language or the text of the contract itself. The next 3 elements, I would call them contextual elements. They are not really in the language of the contract. They are outside the contract. They surround the contract. They are the factual matrix surrounding the formation of a contract. These three contextual elements include the purpose and nature of the contract, trade usages, and the principle of good faith. So we have two textual elements and we have three contextual elements. The primacy is given to the language of the contract, but that language has to be interpreted in light of or in accordance with, depending on which statutory provision you look at, either in accordance with or in light of all these other contextual elements. All right, so what is the recent interesting development? Well, in recent years, a new theory has emerged in Chinese legal commentary and judicial practice, especially in the recent commentaries on the Chinese Civil Code. A new approach to contract interpretation has been advocated by some judges and some authors. This approach is what I may call a sequential and hierarchical approach. Now, what does that mean? Well, here the authors focus on the 5 elements, and they argue that these 5 elements should be applied in a sequential way and in a hierarchical manner. What does that mean? Well, first of all, they argue that those 5 elements should be applied in a sequential manner. So in other words, we have 5 elements, you have to apply them one after the other. You have first to look at the language of the contract term. Suppose clause 3 of the contract is what you are concerned with. So you look at the language of clause 3 first, all right? So that's first, and then after that, you look at the related terms. So you're concerned with clause 3, but probably clause 8 or clause 26 in the same contract are also related to clause 3. So you should look to those related terms. And then after that, you will look at the purpose or the nature of the contract, trade usages, principle of good faith. So you have to follow a sequence, an order. So that's the idea of a sequential approach. The hierarchical approach goes a step further. According to this theory, these authors say, well, actually, you don't need to go to the next element if the prior element, the early element, already give you a clear answer. So in other words, they say, if the first element, that is to say words and expressions, already give you the clear interpretation of the contract, then you should stop. You no longer need to look to other factors or other elements. All right? You only move to the second element, that is to say related terms, if the first element does not give you a clear answer. So in that theory, those 5 elements not only follow a sequence, they follow a hierarchy. Early elements prevail over later elements. So that is what I would refer to as the sequential and hierarchical approach. As I mentioned, this theory was propounded by the Supreme People's Court's commentary on the Civil Code. It was also suggested, although not in so strong terms, by the legislative commentary on the PRC Civil Code. There were also some cases in practice that refer to this theory. Now, one of the cases that is often referred to, often cited, is a 2007 judgment by the Supreme People's Court in the Zibo Wanjie Hospital case. In that case, the Supreme People's Court has this to say about the proper approach to the interpretation of contract. So from that judgment, I quote, "From the perspective of contract interpretation, when the parties have dispute over the meaning of contract provisions, the court must inquire into the parties' true manifestation of intent, and the primary method of determining the true intent of the parties based on review of the literal meaning of the text adopted by the parties. This is known as the doctrine of textual interpretation. So far, so good. Now, here is the kick. Only when textual interpretation fails to yield the accurate meaning of the provision may other doctrines of interpretation be applied to determine the meaning of the contract provision and to fill the gaps in the contract. So that's the Supreme Court judgment in 2007, and that is this theory now proposed also in several important commentaries on the Civil Code. Now, I would argue this theory probably goes too far. It is good that you should take the contract language seriously. Contract language, obviously, is the primary way of the parties expressing their intention. To enforce the contract language is to enforce the intention of the parties. It is the way to enforce party autonomy. But to advocate this sequential and hierarchical approach, I think, goes too far. There are several objections to this approach. First of all, there are theoretical objections. We all know that language does not have meaning if it is divorced from its context. You cannot just look to the literal meaning of some words and say, this is what the parties have intended. One of the examples that I often give to my students is that the word hour has a clear literal dictionary meaning. The word hour, an hour, means 60 minutes, right? But we all know that in many services sector, an hour means 45 minutes. On a university campus, an hour usually means 50 minutes. So you have to look at the context in which the language is used before you can determine what is the intended meaning of a word or the language. So that is the first objection. You cannot really determine the meaning of language divorced from its context. Secondly, there are also practical hurdles. How do you determine that the literal meaning of words already reflect the party's intention? How do you know? Without looking at the context, without, for instance, looking at the purpose and the nature of the contract, it will be impossible to determine that the literal or the textual interpretation is correct. Thirdly, there are also doctrinal coherence in this theory. When we look at the commentaries and when we look at the court judgments that propound this doctrine, we often see clear self-contradictions or inconsistencies. Many judges and many authors are, well, obviously aware of the need to look at the context before you can adopt the literal interpretation. So to say that literal interpretation must prevail over other factors, while at the same time paying regard to the contextual factors, when you look at the commentaries and judgments that preach this doctrine, you often see clear signs of doctrinal incoherence. And finally, when we look at judicial practice, when we look at the overwhelming practice of the Supreme People's Court and the Chinese courts, it is quite clear that this sequential and hierarchical approach is never taken literally. It is never applied strictly in Chinese practice. And one of the clear example is Article 47 of the 2019 SPC minutes on National Court's Conference on Civil and Commercial Trial Work. This is the so-called 9th minutes. In Chinese, it's called 九名纪要. In Article 47 of that document, the Supreme Court was interpreting the termination clause in a commercial contract. And here, the Supreme Court made clear that the literal meaning of a termination clause actually should be disregarded if the principle of good faith would point to a different direction. Now, I don't have time. I know my time is up. I don't really have time to go into that. So how do we assess this approach, this most recent approach proposed by some judges and authors? I think this approach, this sequential and hierarchical approach to contract interpretation is fundamentally untenable. It is fundamentally flawed. But I think in Chinese current context, when you have all of this emphasis on the leadership of the Communist Party, over the Chinese judiciary, and so forth, to emphasize the contractual language, to ask the court to pay utmost attention to the language of the contract as evidence of the intention of the parties, well, that may not be the worst idea. So that concludes my presentation, and I'll hand over to Professor Chao Liu, who will be talking about the law of sale of goods. Professor Liu, you have the floor.
Okay, thank you, Professor Lin Bin, for the presentation on contract law. The topic I'm going to present has something to do with contract law. I'm going to share my screen with you. Okay, so the title of my presentation is Sale of Goods Across the Shenzhen River. And as I stated in the title, this is intended only to be an outline because the research is running on a preliminary stage. I should say a few words about the background of this research. Last year, the Hong Kong government created an initiative to apply the CISG, which is a Vienna Convention on International Sale of Goods, a very successful global convention which has application in a great number of trading nations in the world, including the United States of America, including China, including almost all major trading countries in the world, with a few owning a few exceptions. So I think it's a very good idea that the Hong Kong government considered applying the CSG to Hong Kong, and therefore the Hong Kong government issued a consultation paper, a paper which I and my colleague Professor Wang also have written a response to the consultation paper, and then the consultation paper has later consolidated into a revised proposal to the Legislative Council. And so we can all expect that the CSG is going to be applied to Hong Kong in the near future. And then the question comes, because during the process of consultation, certain parts of the Hong Kong legal community, they have been doing common law in practice for years. So they raised some certain objections, which objections have been seen in the UK when the UK Parliament considered joining the CSG family. So those objections basically is, since the English law also has is make up most of the parts of Hong Kong law, the common law. Okay, if English law is so successful in international trade, why should we replace it with the international convention whose application is so uncertain and whose future is not so well established? Now, that objection, obviously, I don't think is very persuasive. Okay, for the simple reason that the CSG has been adopted in a great majority of trading countries, and therefore, if all these countries adopt this CSG, if the CSG has been interpreted in a somewhat uniform way, then we would create a sphere where we have some common rules, and legal barriers can be significantly reduced. So because of the number of nations which are in CSG family now, so it's a great advantage to any jurisdiction if it considers joining this this body of trading family. So I think I think the Legislative Council has received, the Hong Kong government has received overwhelming support for this proposal, and the next thing is to see if the CSG is applied in Hong Kong, what difference it will make to the law and also to the legal practice. So that's something which I want to survey in this research. And the research question I put is whether and how might legal barriers posed by reason of differences in the sales rules, sale of goods rules in the mainland China and Hong Kong be effectively reduced or ameliorated by the introduction of the CSG. So CSG will have application in both mainland China and Hong Kong. It will, in some sense, flatten out the differences between the two jurisdictions, and what does this mean for the legal practice? That's a question I want to address in my research. So before I look at some of the main differences, I should say that when we say sale of goods law in mainland China, we will mainly look at these laws. First, obviously, is the CCC, Chinese Civil Code, which has become effective from the beginning of this year, especially Book 3, contract. And we also have the Supreme People Court interpretation on contracts for sales, which is very important in this area. This interpretation is a judicial interpretation which is has binding force in China, and it has been updated in 2020, so it has force now. Even though the original interpretation was issued on contract law. And then we have a number of other binding sources like guiding cases. And we have two cases relating to sale of goods, but they both concern consumer sales. But later we will see consumer sales is actually not something we will look at. I will look at in my research. There are other rules or cases of a guiding effect which might also be considered in my research. So if we turn to the side of Hong Kong law, sale of goods law in Hong Kong is mainly composed of common law rules. So we have common law rules which basically coincide with contract law rules in this area. And there are other specific rules applicable to sale of goods, but they mostly concern property law issues and other issues. We also have a number of equity rules, like rules governing specific performance or unconscionable conduct. So, but apart from this, we also have a number of contract statutes which are very important in this area. Like particularly, we have sale of goods ordinance. So I'm going to refer to that ordinance a number of times later. So those are the laws we are going to look at to compare in order to see what the major differences between the two systems are. But something I need to say at the beginning is the areas in which the CSG might be of assistance. There are certain areas which we can clearly see the CSG can be of no assistance at all, because the CSG has said very clearly the CSG has application only in certain areas, and other areas have been excluded from the scope of application of the CSG. Examples like consumer sales. Now, if we look at the Hong Kong law and the Chinese law, we will see that one area in which the two systems differ significantly is relating to contracts involving a consumer. So they define the notion of consumer differently. Okay, they impose different disclosure duties, and they fashion different remedies. However, because CSG has nothing to say on consumer sales, so our research will not look at consumer sales, because this is the area the CSG can do nothing about the difference between the two legal systems. Okay, we have to find all them different measures to tackle those differences. Apart from that, CSG also has no application to sale of securities, bills, ships, aircraft, electricity. And the CSG does not deal with contract validity. So issues like illegal contracts and contracts invalidated because of one party's consent being vitiated, those issues are not dealt with under CSG, and therefore are not going to be surveyed in our research. And this also includes proprietary effect of a contract, property law issues, like in a sale of goods contract, when does title pass, and is the title good against a third party? Those issues will not be covered in the research, and also tortious liabilities is not covered. But there are also some areas in which the applicability of the CSG is in doubt. We don't know, we're not 100% sure whether CSG has application or not. For example, there is a contract for work and materials. Is this a contract for sale of goods? Well, that depends on the legal test, and the CSG adopts a test of substantial part of the materials supplied by the party who orders the goods, and there is another test which says that the preponderant part of them of the other parties' obligations is to supply labor or other services. Now, CSG does not apply to those contracts. But if we look at the Hong Kong common law, a different test is applied. So here we don't know, and in a given case, whether CSG or the Hong Kong common law will apply. Another possibly more important issue or type of contract is a contract for sale of software or other digital content. Now, in this digital age, that type of contract will be gaining importance, but we are not sure whether CSG applies to that sort of contracts. But I think because of the importance of this type of contract, I think the CSG will try to assert some influence over that type of contract, but that remains to be seen. So apart from these areas, if we look at the mainstream of contract law, and we will see that CSG, Hong Kong law, and Chinese law, they cover some of the overlapping areas. So it is those areas that form the focus of my research. If we look at those areas, we can outline some of the major differences between these three sets of laws. But the differences outlined below are somewhat technical, so perhaps there are too many details in there. So I'm not going to go through all of them. Instead, I will try to draw some general lessons from this comparison. So in short, if we look at contract formation, then the message is very clear. That is, Chinese law and CSG, they are largely similar. And they differ from Hong Kong law in a number of different aspects. Those aspects include, number one, parallel evidence rule is a unique rule in the common law system. It basically says, if a contract is embodied in a written agreement, then neither party can alter the content of this written agreement by adducing evidence in relating to anything outside this written agreement. So this is parallel evidence rule. And obviously, this parallel evidence rule is not accepted in civil law traditions. It's not accepted in China, mainland China, or the CSG. So if CSG applies, parallel evidence rule will be displaced. And a party can adduce any evidence to prove the content of a contract. Another example is a firm offer, and this is also a thing that a common practice in international trade, where one party makes an offer, and he says this offer, he promises the other party the offer will not be revocable, Okay, in the common law system, this promise is not binding because there is no consideration supporting the promise. But in civil law countries, so as shown in CSG and Chinese law, such a firm offer has some legal effect. So again, in this respect, CSG, if applied, will change the common law. Mirror image rule, common law insists that acceptance must correspond precisely with all the terms in the offer. But CSG says, as long as the changes are not material, acceptance will also be effective. Postal acceptance rule, common law says that in certain situations, acceptance may take effect at the very moment when the acceptance letter is posted in the mailbox. That rule is not accepted in CSG or Chinese law. And the general rule is that any communication must be notified to the other party. So from this, we can see the contract formation rule. Chinese law and CSG are sided with CSG, and they will replace common law with respect areas of difference. If we turn to contract terms, I think I will just mention 2 points. One point is about the common law rule of uncertain contracts. Okay. Now, under common law, if a contract is adjudged as too vague or incomplete, it will be void for uncertainty. Even though there are cases, like the case I mentioned here, New World Development, there are cases which says in a commercial contract, the courts should do the utmost to make the contract working, instead of declaring the contract void for uncertainty. But there is still a rule which says that in certain situations, the courts cannot take a proactive role in rewriting the contract. Okay, if the contract is simply too uncertain, then the court has no other option but to let it pass. That is be invalidated. In comparison, if we look at Chinese law, we will see that Chinese courts have much more scope or power to fill gaps in contracts. If there is a gap, the CCC Article 511 says that you just need to insert standard terms or common terms accepted by the profession, by the industry, or by ordinary people. So that's really considerable discretion given to them and power given to the courts. Another thing, obviously I don't have much time left, so I think I will be quick to wrap up things. Another thing which I want to mention is about implied terms. Now, the Sale of Goods Ordinance in Hong Kong says very clearly there are implied conditions as to description, fitness for purpose, and quantity. So if the seller delivers goods which are not in conformity with these requirements, it will be a breach of condition. A breach of condition will give the buyer a right to reject all the goods or to terminate the whole contract. That is very, very much different from the civil law, from Chinese law and the CSG, where whether one party can terminate the contract depends entirely upon whether the breach is fundamental or not. So there is a fundamental breach test. That's a major difference. But again, we see in that aspect, Chinese law and the CSG, they are broadly similar, and they are different from Hong Kong law. So based on these examples, I don't have time to go through all these details. But if you are interested, you can look at those differences outlined in the slides. So I will come straight to my conclusion. So if you look at all these differences between in different areas of sale of goods, you will see that in most cases, Chinese law is similar to the CST. Well, that is understandable because when Chinese contract law is drafted in 1999, it was primarily based on international instruments, including the CST. So as a result, the implementation of the CST in Hong Kong has the effect of pulling the Hong Kong law towards a more pro-contract, yet still pro-commerce position, which is relatively closer to the mainland Chinese law, and thereby presenting a rare, valuable example of limited harmonization between the two legal systems. The two legal systems, I mean the Hong Kong legal system and the Chinese legal system, the legal system in mainland China. So through this vehicle of CST, in certain areas, the law might be harmonized by reaching a compromise at some middle points. What remains to be done is that even though as a matter of principle, we can see that Chinese law and CST are similar, but there still is much to be done, to be worked out in terms of the extent of concessions Hong Kong law is to make, and how Hong Kong and the mainland courts ought to achieve uniform or at least a consistent interpretation of the CST provisions. So in the future, I think we will have further studies on when the cases come out, on how the courts on the two sides of the Shenzhen River interpret the same provision in the CST, and we will figure out how better harmonization of law can be achieved. So that's the main point of my research. Thank you for listening. By the way, we will leave all the questions to the end of this webinar. And next, we will have our next speaker will be Professor Wang Jiangyu, my colleague, and he's going to talk about an issue of international law.
Yeah. Chao, can you stop sharing? Can you leave the screen? Thank you. Wonderful. Okay, can you see my slides? Okay, sure, great. Thanks, Chao, for the introduction, and it's an honor to present after Professor Lin Bing and Professor Liu Chao, two great scholars and two of my very best friends. They are both wonderful contract law scholars. So let me try to move the theme from private law to very much a mix, a hybrid of private law and public law, and also a blend of law and politics. So my topic is actually about the practice of CSR, corporate social responsibility in China. My argument is corporate social responsibility is actually corporate political responsibility. So in the Chinese context, the corporate social responsibility is something designed to achieve a wide range of political objectives. So CSR in China actually has a national character. So the practice of CSR is a top-down process, as compared with CSR as a concept in the Western society, as a bottom-up concept through which individual companies do things to have positive impact on the whole society, on the whole society to make the world better. Let me start with some definitional issues. Okay, why it doesn't move? Okay. Sure. The buzzword nowadays is ESG rather than CSR. So being ESG being environmental, social, and governance and governance practice. It is very much a reporting system and a disclosure system. The ESG is very much derived from the old concept of CSR. So compared with the ESG and CSR, compared with the ESG, there are some similarities. So these share the same genesis. They are both for the purpose of encourage corporations to adopt policies and practices to make the world better, especially with respect to environmental protection and the society and the stakeholders. Right? So, but these are also two different concepts. The CSR as the precursor to the ESG, it is very much the external behavior of the company. It is self-regulatory measures. So a company promises or actually does something to have positive impact on a number of things, and the stakeholders, including the communities, the environment, the whole society, and the employees, the consumers, and others. And so the CSR is very much a qualitative concept, while the ESG offers some numeric benchmarks, numeric quantitative indicators to internalize those commitments, right? So it requires company to implement it requires a company to very much embed those lofty goals in its daily routine internal making process, and so as to let the investors and the consumers to understand the moral, the ethic aspect of the company for them to make decisions. Because some investors, so investors are consumers, many investors are consumers, are willing to pay more for the company. So from the investor's perspective, the investor love to invest, buy the shares of the company which has good ESG practice, and the consumers the same. Consumers are willing to pay more for the green products, right? They are willing to pay more for sustainable products. Right? So ESG is very much has already become an investment strategy. And but they do, as I said, they do share the same genesis. So because my argument is more related to companies' external behavior. So although I might use CSR and ESG interchangeably, but the focus is very much still on the CSR. And the purpose of this idea. So this is a working in process. So the argument is still being developed. So the idea is still being developed. I can only offer an outline here. The essence of the paper is about the political logic of CSR, ESG in China, and so let me jump to the main argument part. But before I do that, I just want to let you know that China has become, at least based on the ESG and the CSR and the ESG practice, so China has become a leading jurisdiction for CSR and ESG reporting, and you have thousands of companies, of listed companies, delivering annual CSR reports, and many of them are now delivering ESG reports. Although CSR is still very much the official officially endorsed the concept, and the ESG is very much a civic concept. So, meaning that they are not yet mentioned in official documents mentioned by the states, but the quite a number of companies, about a quarter of Chinese listed companies are delivering annual ESG reports these days, in addition to the CSR report delivered by close to 2,000 listed companies. And the very brief introduction to the historical evolution of the CSR movement in China. So it was very much a foreign concept. CSR entered into entered into very much the conceptual domain or the intellectual domain of the Chinese society in the 1990s. But before 2006, that is when the Chinese company law was revised, was basically rewritten in 2005, which took effect in 2006. The CSR was very much an intellectual concept and a foreign concept, and used by some foreign companies to very much to develop their brands, right? So brands for being environmentally friendly and socially accountable enterprises. So it was basically an advertising point used by international companies, but not by Chinese companies. And things began to change in 2006 when the Chinese company law officially codified the CSR. So China is probably one of the very, very few jurisdictions which actually use law to codify CSR obligations. We'll come back to this point in a more detailed way later. And there you have the Sichuan, you have the Wenchuan earthquake in 2008, and a call was made by the Chinese government. So basically by the State Council and the Central Chinese Communist Party Committee to call on companies to help out those victims in the Sichuan earthquake in the Wenchuan area. And in the same year, the regulator of the state-owned enterprises in China, the SASAC, issued guidelines on CSR, and now CSR has become a prevailing and universal practice in China. So it has become or precisely in corporate China, CSR has become such a prevailing practice that almost all the important companies are doing that. So this is an historical evolution of the whole process. So as I mentioned, my main argument is that the CSR is actually CPR, and the ESG is actually ESP. So the CSR is not social responsibility, is actually political responsibility, or it has been driven mainly by political factors, by political driving forces. And so the whole process is led by political logic rather than other objectives. And I would have 4 sub-arguments, which of course all needs empirical support, but I'm just can only offer an outline of the ideas here. So the first argument is that the CSR is the state-imposed. CSR, so as a responsibility, it's initiated very much by the state. It is the state-imposed responsibility. And the second sub-argument is that it is SOE-led. So the state-owned enterprises are leading the edge in CSR performance. And the third sub-argument is with respect to the performance, the performance in reality. So in practice, the contents of the CSR are very much policy driven, and And the fourth sub-argument is it is also politics-driven, and is also politics-driven. So very quickly on the first sub-argument, state imposed the CSR, as I mentioned. The CSR movement started in China with the codification of the CSR as an legal obligation, as actually several legal obligations in the Chinese company law. Let me move backward to a few slides on the law. So the Article 5 Chinese company law requires companies to do a number of things, including most significantly bear social responsibilities. So this is called the CSR provision, the CSR clause in the Chinese company law. I haven't found any other jurisdiction that has codified the CSR, although in a very vague way, in a very ambiguous way, but it is a codification of very much a moral obligation, so very much of something regarded as moral obligation in other jurisdictions. Right? So not only Article 5, and it also has a few other provisions quite similar to that contains obligations they fall within the arena of the CSR, right? For example, Article 19 of the Chinese company law asks companies to protect its workers and to provide them with social insurance and strengthen labor protection, and the Article 18 requires companies to allow workers to organize trade union, and Article 19, so arguably part of the now has become a salient feature of corporate governance in Chinese companies, especially in state-owned companies. So each company is actually required to permit the employees. So the Communist Party members to establish party cells, party organizations in each company. And there's the literature about the political control, or the literature about party building is being developed in a rather rapid manner these days. Right? So come back to my first sub-argument. The CSR, it actually started with the codification of CSR in the Chinese company law, and the CSR movement began to emerge and begin to develop, begin to boom, begin to flourish only after this codification. And there are also rules made by the two stock exchanges, Shanghai Stock Exchange and the Shenzhen Stock Exchange. So they also facilitate, and those stock exchanges not only facilitate, their rules are regarded as self-regulations, right, as self-regulatory rules, but they are very much from the perspective of listed companies. Those rules are actually hard rules. You have to comply. And the CSR reporting of listed companies is very much a response to the requirements of the stock exchanges. And then also you have the SASAC. So as the regulator, as both a regulator of state-owned enterprises and also reminded I have 3 minutes. Okay. So the SASAC also very much in the form of guidelines, but very much in the form of essentially, those are essentially requirements. So require state-owned enterprises to do CSR, and especially do CSR reporting. Okay, policy-driven. Then my third argument, so which basically means that the contents of the CSR reports issued by Chinese companies, they are very much, to a very large extent, they actually, if you do empirical investigation of those reports, the contents are actually quite similar. That is very much because the the main portion of the contents is very much a response to the requirements of the state, from time to time. So depending on the requirements, depending on the policy orientation of the states, for example, if the states encourages companies to plant trees, right? Plant trees and to protect the environment or reforestation. Then the companies will do that. The companies do that. If the states hope the companies to help the society to help kids to get to school, then you will see a lot of CSR. There's a lot of companies states that in their CSR they have built so many so-called the 希望小学, so the hope primary schools. So that's the content of the CSR. And the last one is it's also politics driven. So politics driven in the sense that the CSR, so companies do CSR because they believe this is the politically correct thing to do, especially as a response to the call of Chinese top leaders and Chinese top leaders. So the Chinese, in these days, many companies do CSR as a direct, as an explicit response to the call of Chinese President Xi Jinping on the adjustment of the excessive income and to give back to the society in order to achieve common prosperity or shared prosperity, so-called 共同富裕. So we actually, it's very easy to find a number of cases, right? So two more significant cases are recent commitments of Alibaba and Tencent. So each committed 100 billion Chinese yuan to, as clearly stated, as response to President Xi's drive of common prosperity for the Chinese society. So these are for those reasons, I would argue that corporate social responsibility is very much corporate political responsibility. So again, this is just an outline of an idea, and the empirical material has to be found to support those the argument and the sub-arguments. So that's very much my presentation, and let me thanks for your patience, and let me introduce the next presenter, Professor He Tianxiang from the School of Law of the City University of Hong Kong. Tianxiang, the floor is yours.
Okay, thanks very much, Jiang Yu, for your kind introduction. So I would like to share my slides first. Okay, thank you very much. And I'm very honored to have this chance to share with you of my recent research about AI and copyright issues. So basically, the topic is not just about China, but it is based on China as an example, and to see how we can deal with this so-called AI copyright crisis. So that's why my topic is set at towards a regulatory framework of AI copyright crisis. So basically, for those who are not very familiar with the field of IP, when we're talking about copyright and AI, so there are in general 3 major issues being identified. The first thing being the copyright creativity, which concerns the legal determination of who should be the author and who should be the owner and proprietor of such exclusive rights. And the second issue will be filtering technology employed by platforms in detecting copyright infringements online, massive copyright infringements online. So that's basically is an issue, concerns, and enforcement, right? And most of these filtering technologies nowadays are employing algorithms rather than using manual, decisions. The third issue is what we call the IoT, or data mining and AI analysis exceptions, which concerns copyright exceptions, because in general, copyright is a very unique private right, because it builds on the previous human knowledges, accumulated by the society. So therefore, it has sort of like a public interest, phase in terms of the protecting the interests of the copyright owner. So therefore, that is not just the only goal of the copyright law, and the rest of the goal should be balancing between the interests of the copyright owner and the public interest in assessing and using knowledge. So therefore, there is a specific section of copyright law concerns exceptions. So that tells you under what situation people will be able to freely make use of copyright contents without asking for permission and license, right? Such as educational purposes, such as when we're teaching in the university, we don't have to ask permissions from the copyright owners when using textbooks and materials using our slides. That is because the copyright law has an exception, section. Okay, so the fourth part is that I'm going to discuss today is about how to solve these issues and why law is not enough. And the fifth part is a conclusion, is that my preliminary envision of what should be the regulatory framework. Okay, so for the first question, creativity, we can see that AI technology has nowadays, and its application have profoundly changed the ecosystem of copyright and challenged the traditional copyright jurisprudence, right? So the first challenge is the concept of copyright itself. According to my previous research, you can see that there are many, many examples that AI can now generate contents similar to human expressions, such as paintings, articles, poems, and music. So machines will be able to generate, contents that are similar to human creations that used to be protected by copyright law. So then there are two major issues here. The first thing is that whether we should give AI legal personhood so that it can enjoy a copyright over its creations by itself. And second is that if not, then the next question will be whether the AI generated contents are copyrightable and to what degree shall we protect them. So for the first question, it's highly doubtful that we should do that, because most of this argument is that saying because the legal system that we have today is actually built on a human-centered ideology that and everything, the basic idea is built on, a human, proprietor or a human author within different laws. So, so if we want to change that and introduce machines as proprietor, or or give machine personhood, there will be, that will need a fundamental change in terms of our legal system, because many of these concepts have to be, sort of abandoned. So for the second question, actually, I have concluded that the copyright theory requires a human author, because if you go back to the copyright jurisprudence, you can see that recognizing AI as an author, recognizing AI machine as an author is intrinsically in conflict with the copyright jurisprudence. For example, copyright has two, sort of like schools. For example, one is what we call the author's right jurisdiction, which basically come from Germany and France. So the theory is that they put authors in the center. So the theories, therefore, they built related to originality and moral rights, and especially the justifications backing the copyright protection, such as utilitarian theory and personality theory, are all linked with a human author. So for example, there's a traditional theory backing up copyright protection, is that the belief that a work is an expression of an author, therefore it carries the author's personality, right? So for example, I write a book, so therefore the book represents part of my personality. So that comes, derives from that. People can design, moral rights protections, such as the rights to have name associated with their work, and have the rights to object to derogatory treatment of your work. So that's basically all linked with the concept of the human author. So the conclusion is that either we need to identify the human player inside the whole AI creativity process as an author, because you cannot place a machine as an author, because that is against the whole idea of copyright. Well, then we need to find an alternative solution that could bypass the author issue, right? Basically, that is the question in this field. So the next question is filtering technology employed by content platforms, which concerns basically identifying copyright infringement using technical means. So whenever you upload something to the platform, it's not a human that is overseeing whether these contents are, dangerous, or whether it's heterodox, or whether these contents contains copyright infringement materials. It is a machine or algorithm that's based on certain parameter that decides whether this content should be allowed to be uploaded to a content to a platform or not. So users uploading infringing contents to platforms is a complex problem today, especially for those partial borrowing cases. What I mean partial borrowing is that, traditionally when we're talking about piracy, we're talking about people uploading the whole movie to a platform, so which is very simple because that is more like a 100% copying. And whereas today is more like people borrowing contents from copyrighted works, and they mix their labors and they create something new, and such as a video, and upload to the platform. So basically, they partially borrowed contents from a copyright work, but they mix their own labors and ideas and contents together. So that will be much more difficult, because then there is a problem in identifying whether those borrowing should be justified or not. Due to many reasons, you can see that targeting users is deemed not a good idea by many copyright owners, as they have turned to the platforms for secondary infringement claims, because then we'll be able to recoup the investment, because suing individuals will not get money, but platforms are a deep pocket. You can say that because platforms are assisting the users in terms of helping them to commit infringement. So therefore they should bear the liability as well. So therefore they will be able to pay damages. So but platforms are important to our digital economy, right? So the solution proposed around year 2000 is what we call the US DMCA safe harbor rules, that aims to exempt platforms from secondary infringement claims if they followed what we call the notice and takedown procedures. Simply put, is that when because the numbers of daily upload is too huge, especially consider platforms like YouTube, it's impossible for them to monitor each and every upload, right? So they will sort of have to wait until a corporate owner sends a notice to the platform. The platform then will know that there's an infringement case, then they will remove the contents, then they will not have to be liable for the infringement associated with it. So the law indicates that no one is obliged to identify infringing contents being uploaded to platforms such as YouTube until they were notified by copyright owners. So but soon, humans are replaced by technical means such as algorithms, even though platforms are not obliged to do so, but because platforms want to attract copyright owners, and that will also help to reduce litigations, which are costly and time-consuming, and technology means, technically, machines are faster and sometimes more precise than human in detecting some of these, infringing contents. However, the downsides of the filtering technologies is that it still has the potential of making wrong decisions if the decision is based merely on, for example, percentages. For example, basically now, currently the algorithm is just based on percentages, saying that how much you borrow from an existing work, and up to a certain percentages, then it will be deemed infringement. Therefore, you will not be able to publish your contents on the platform. And the real threat is to the fundamental rights embodied in the copyright law, jurisprudence such as the freedom of speech in fair use, as copyright also serves a public purpose of delivering speeches and disseminating information and knowledge. So if machines can make a decision to block certain speeches even before it was published, then there is a huge risk that people will be sort of censored in terms of the things they want to express in the contents they want to upload to the platforms, right? The different countries of even courts may have different understanding about what could be considered as fair, right? So algorithm rules will result in a scenario that the platform in practice has taken over the role of the court in deciding fair use cases that cannot simply decide by percentages, because if you have some knowledge about what we call the fair use, is sometimes that is a balance mechanism that the court can decide in certain cases that certain ways of utilizing copyright contents shall be set free, right? But this decision is very complicated because there's no like a casebook list telling you what kind of way of utilization will be considered fair or not. It's basically a case-by-case analysis and has to go to the court. But now, if algorithm decisions can, based on percentages, block contents, then they are actually replacing the role of the court in deciding whether certain contents are fair or not. But in fact, they are not qualified to make such decisions. But some believe that the negative sides are trumped by the positive sides, so that they advocate a future algorithm such as the DSM directive in EU. So the last example is I would like to share is the use of data in AI analysis, because nowadays digitalization and IoT, Internet of Things, have turned everything into data, right? So everything, the gadgets we have, the watches, the cell phone, and even the computers we carried, or generate our personal data on a daily basis. Some of this data collected for data mining content, for example, people want to do data mining, activities that which contains copyright works, such as paintings and songs, or even articles that as academics produce. The problem is that if you want to do data mining over these contents, is that it's impossible for the AI user to obtain license from each and every copyright owner when the data is huge. For example, if you want to do data mining on all articles related to cancer, if you want to dig out some patents, you want to use all the articles published, copyright articles to do data mining, and then the problem is that traditionally you have to ask permission from each and every author. So if you gather like 1 million articles, then you have potentially you have to ask for 1 million permissions, right? So it is impossible. But for this kind of application, a nearly complete data set is indispensable. So on the other side, it is very necessary for you to gather as much articles as possible, right? So many have suggest that at least the copyright law should give an exception or fair use of these kind of uses. So I have written a chapter about a proposal for China. So other jurisdictions have taken the lead in creating rooms for AI analysis of data in the copyright laws, such as the EU and Japan. So, and people say that US fair use model is already flexible enough to cover it. So till now I have demonstrated 3 challenges faced by copyright law in our current legal solution proposals. But law is definitely not enough. For example, when we're talking about AI creativity, we could still figure out a way to provide them with legal protection, no doubt. But there are some problems that cannot be fully addressed by the law. So for example, the dilution problem is the most urgent one as it concerns the powerful AI that could generate contents much faster than humans, and people will not be able to distinguish human-created contents and AI-generated contents. So how can we make sure that the market will not be overwhelmed by AI creations, right? For filtering technologies, making them mandatory will bring in the issue of cost. Also, it will cause concentration of platforms, as all the titles are gathered in several big platforms, and that will in fact give platforms the superpower to control speech, as there is the black box issue of the algorithms, and this mechanism is sometimes abused in helping governments censoring contents in the name of fighting piracy as well, in the case of China. So for data mining exceptions, and providing users an exception is not going to solve the access problem, because the problem is that without proper channels, there is no way for one to access restricted data controlled by big companies. For example, even if the law says that, okay, you feel free, you have a copyright exception for data mining purposes, but how can you get access to those data if the data is controlled by big companies? They will not open their data set to you, right? Just because you have a copyright exception. So they would say, okay, you have an exception, but you can get it yourself if you have the ability, but I won't open my data set to you. So the future path I suggest is sort of like a regulatory framework that consists not only legal solutions. So for example, the dilution problem of AI creativity, we can set technical requirements using technologies to solve part of the problem, such as mandatory digital signature that force the AI creations to reveal themselves in the market. So you will go to the market, and if you want to buy a painting, you can see that certain painting is labeled as AI generated content, then you'll be able to distinguish the two. For filtering technologies, even though the focus is mostly on percentages of borrowing, but as it concerns free speech, the black box issue must be solved. So basically it means that the algorithm should be disclosed to a degree. 3 minutes left, thanks. Algorithms should be disclosed to a degree. So some will argue that the market will force the platforms to improve their algorithm, but the concentration will stop that from happening. The disclosure will provide more information to users and help them decide whether complaints are necessary. And this could avoid, like a secret censorship filtering in disguise of copyright filtering. So this must also be a remedy via which the users could challenge the decision. So in terms of data mining, the exceptions provided by copyright law, as I just explained, cannot solve the access issue as data is controlled by companies. But as the focus is copyright works rather than other types of data, so data holder cannot be forced to open data widely because they do have exclusive rights over the contents that we have. A better mechanism is to set obligations to cooperate and limit the requests only to justifiable ones, or promote prioritization to facilitate voluntary exchange. As the data holders do have copyright protection, so it will be better if a designated institution such as the collective society could collect a sum of money that could compensate the expenses related to facilitating the users with regard to access to data and maintenance. Of course, the eligibility determined by the exception should be extra clear, and the courts should provide assistance in confirming that. So the above problems shows that for AI applications that will have profound implications on our society, regulatory measures should be there to minimize the negative impacts. So in the AI era, law as a regulatory measure is necessary, but it is not enough. So even though we can see that the EU has initiated the AI Act as a regulation in 2021, but we should also be aware that not only technical measures could provide help in regulating the AI copyright crisis, but we also need to consider the industrial norms, such as the code of conduct and market power, and come up with a comprehensive regulatory framework. Okay, thanks very much. I think that's the end of my presentation, and I will be very happy to take on any questions in the Q&A section. And next, I would like to introduce my colleague, Professor Peter Wang, Associate Professor Wang Shucheng, and from CTU School of Law. Thanks very much.
Okay, thank you. I'd like to share my screen. All right. Okay, thank you very much. My name is Peter Wang from CTU University of Hong Kong School of Law. It's my privilege to present my draft paper on a dialogic approach to the interpretation of Hong Kong basic law. And the discussion is mostly theoretical. As we know, under the arrangement of one country, two systems, Hong Kong has adopted a different system from that of mainland China, and it remains a common law jurisdiction. The Hong Kong Basic Law, which was made by the National People's Congress, NPC, as the highest justiciable law in Hong Kong, accordingly provides Hong Kong with a high degree of autonomy to enjoy executive, legislative, and independent judicial power, including that of further education in accordance with the provisions of the Basic Law, except those as reserved by central authorities, namely Foreign Affairs and the National Defense. In addition, it also provides two constitutional mechanisms of the interpretation of basic law as stipulated in Article 158, namely the Courts of Hong Kong and the Standing Committee of the National People's Congress in Beijing, NPCSC. The interpretation of the basic law by Hong Kong courts is practiced in a common law approach, while the one by the NPCSC is of legislative nature and shall be followed by Hong Kong courts with no retrospective effect. However, such a constitutional reconciliation of Hong Kong's common law approach with the non-common law approach of the NPCSC is not uncontroversial in practice. In particular, the NPCSC's interpretation, though based on China's sovereignty, is often criticized as an intrusion into Hong Kong's rule of law order, mostly based on liberal principles of common law as practiced, because the NPCSC, as the executant of the NPC, is in essence a bureaucratic apparatus rather than a judicial authority, and the operation of the NPCSC is also not based on a liberal model of democratic elections. Of course, the one country the one country component, as entailed by the one country two systems, has been delineated by the basic law. On the one hand, the courts of Hong Kong shall have no jurisdiction over the acts of state, namely defense and foreign affairs. On the other hand, if Hong Kong courts in adjudicating cases need to interpret the basic law concerning matters relating to central authorities, the courts shall, before making their final judgments, which are not appealable, seek an interpretation of the relevant provisions of the basic law from the NPCSC through the Court of Final Appeal of Hong Kong. And this seemingly irreconcilable mechanism between Hong Kong's judicial independence as the basis of its rule of law order and NPCSC's determinate authority in interpreting the basic law for maintaining the symbol of sovereignty, the one country, has been practically activated in the case that is Conco case. The Conco case, of course, involves which doctrine of state immunity, i.e. absolute or restrictive state immunity, should be adopted in the jurisdiction of Hong Kong. As the state immunity has been manifestly a matter relating to central authorities, and the Court of Final Appeals finally sought the interpretation of the basic law concerning foreign affairs from the NPCC before the final judgment was rendered. And the Conco case seems providing a concrete channel of reconciling the CFA, the Court of Final Appeal, and the NPCC regarding the interpretation of relevant provisions of the basic law if relevant to central authorities. However, the coexistence of NPCC's interpretation and Hong Kong's judicial independence has not been streamlined theoretically due to the contrasting basis of two different interpretive mechanisms in the basic law. The interpretation of Hong Kong courts is legitimately based on the common law approach, while the NPC's constituent power to make the basic law and NPCC's interpretation of the basic law are based on China's sovereignty under Chinese Communist Party's absolute political leadership. And in particular, NPCC's interpretation is determined with no constitutionally effective external oversight mechanisms on it. I will discuss a little bit on this, which has led to some practical worries about the exercise of NPCC's interpretation, which may intrude into the rule of law order of Hong Kong inappropriately. Of course, under the one country, two systems, the one country element entails the NPCC's interpretation because these affairs relating to central authorities, including foreign affairs and national defense, as written in the basic law, are excluded from the jurisdiction of Hong Kong. And due to the contrasting political foundations of two different interpretative mechanisms of Hong Kong and China, respectively, the maintenance of one country, two systems entails two sometimes contrasting values and systems of Hong Kong and mainland China, respectively. Such a difference may naturally lead to different or even sometimes ideologically confrontational rationality based on which different interpretations of the basic law may be made. And in order to maintain the one country, two systems, this logically entails a mature difference between each other. To a certain extent, any exclusive assertion based on some rationality without respecting the other is likely to make the one country, two systems imbalance. Of course, the question here is how to constitutionally place NPCC's interpretation in a suitable position as compatible with the one country, two systems, and not as an intrusion into Hong Kong's rule of law. And well, as the constitutional purpose of one country, two systems is to maintain Hong Kong's common law system as demarcated differently from China's non-common law system, as manifestly reflected in the basic law. This actually entails that the one country is mostly symbolic and subsidiary, to Hong Kong's common law system based on the high degree of autonomy. Of course, this symbolic component is not a vacuum and has been constitutionalized through China's sovereignty claim in the basic law that Hong Kong is a part of China, right? And it's specifically the exclusion of the acts of state, namely the defense and the foreign affairs from the jurisdiction of Hong Kong courts. For example, then you can see the difference, right? In understanding the one country. The one country, namely China, under the one country, two systems cannot be understood simply from a mainland China's perspective because The former engages with the politics of difference from China, and the latter engages with the politics of unified principles and institutions. Right? So, for example, as a subnational unit of mainland China may be delegated by the central authority to experiment innovative and different system in some area, such as this in Shanghai or Shenzhen. Nonetheless, the constitutional purpose of these experiments or varied practice at the subnational level of mainland China is by no means to develop and maintain a heterogeneous system as separated and demarcated differently from that of the plural party state. And specifically, to understand the meaning of the symbolic component of the one country, there are at least two situations that can be practically delineated. The first symbolic component of one country as practice is reflected by the subsidiarity of the principle and the subsidiary function of one country. That means when Hong Kong system on its higher degree of autonomy is not self-contained anymore to deal with the matters concerned, NPCC, in the name of one country, needs to take no more than necessary measures in order to maintain the integrity and the continuity of Hong Kong's common law system as constitutionally entailed by the two systems of the one country, two systems. Right? The second symbolic component of one country is reflected by the unchallengeable sovereignty of the one country, China. Due to Hong Kong's international status and its practice of Western style of common law system with liberal principles to a large extent, it's understandable that these principles and institutions as practiced in Hong Kong are quite different from those of mainland China under CCP's political control. And for geopolitical reasons, there may be ideological tensions or even conflicts. If Hong Kong's practice of the common law with liberal principles has been politically either explicitly or implicitly penetrated into the political space of mainland China, even sometimes with a political threat to the party-state regime. And it is understandable that CCP is more likely to take repressive measures to eradicate any geopolitical threat of this kind if it arises from Hong Kong. Somehow for the fear of the possibility of color revolution or whatever against its party-state regime. And this may be partially evidenced by the promulgation of the national security law as imposed by the National People's Congress for the purpose of bringing Hong Kong to the normal from the large scale of anti-extradition protests which was developed into an extreme chaotic one at a later stage with violence and vandalism involved. And sometimes even with some extreme anti-China slogans, as you can see from the protests, right? And which have somehow arguably become a geopolitical threat to the party-state regime, right? Due to it has been outside Hong Kong's rule of law order and out of control by the government, as well as you can see the tremendous attention and support from the international community. This definitely has been unable to be politically tolerated by the CCP, which you can see finally launched the lawfare, namely the promulgation of the national security law, in order to prohibit these politically threatening social movements to not just Hong Kong's rule of law order, but also to the party-state regime. So apart from these possible direct geopolitical challenges or threats, as mentioned, there may arise some indirect challenges or threats in the sense that the operation of the two systems, two extreme, has gone beyond the imagination of mainland Chinese people that Hong Kong is a part of China. For example, during the oath-taking controversies, some pro-democracy lawmakers' derogatory oath, including the pledge allegiance to the Hong Kong nation or pronouncement China as China, a derogatory term used by Japan during the Second World War, as well as displaying the banner with the words Hong Kong is not China, etc., definitely has crossed the bottom line of the imagination of mainland Chinese people that Hong Kong is a part of China under the one country, two systems, with their subsequent strong populist reaction against it, apart from the indignation as expressed by central leaders of China. Against the background of a strong nationalism in mainland China and the understandable populist pressure on the central authorities, it is sometimes understandable that there is a political need from mainland China's perspective for the NPCC as China's legislature and a responsible authority in charge of Hong Kong affairs to take a political action to visualize the imagination of Chinese people of mainland China that Hong Kong is a part of China. To some extent, as Hong Kong's common laws have been self-contained to resolve the manifestly illegal issues as involved in the oath-taking controversies. The NPCC's interpretation of the Article 104 of the Basic Law regarding the office holders swearing to uphold an allegiance to the Basic Law actually has played almost no legal role in the judicial decision making. And furthermore, you can see NPCC's interpretation was even manifestly disregarded in the judicial decision of Hong Kong courts because of the sufficiency of Hong Kong's common law for dealing with the illegal issues involved, as you can see from the oath-taking case. In this case, the Court of Hong Kong did not rely on the NPCC's interpretation, but actually substantially on Hong Kong laws to make the final judicial decision. And the court had somehow made a circumvention of NPCC's interpretation as a directly relevant basis for the decision making. And interestingly, this did not lead to any political reaction from the NPCC, because we can understand that judicial decision has resolved the illegal oath-taking issue, which at the same time has made these populist reactions in the mainland China mostly disappear, as well as those populist pressures on the central authorities of mainland China. Right? In this regard, NPCC's interpretation actually played a significant political role, as it is able to politically cement the people's imagination in mainland China that Hong Kong is a part of China, which is an essential symbolic component of the one country, two systems. All right, of course, there has been no effective constitutional authority as the guardian of the one country, two systems in practice. The NPC, yes, as a constitutional authority to amend the Basic Law, has a higher constitutional status than both the NPCC and the Court of Final Appeal of Hong Kong. Nonetheless, we know the operation of NPC is not based on liberal principles and only has one session lasting for around a couple of weeks annually. And the function of the NPCC is primarily to procedurally endorse these decisions determined by the party and relevant political authorities. Right? In this sense, institutionally speaking, the NPC is practically incapable of acting as a guardian of the one country, two systems, ensuring NPCSC's self-restraint approach to the interpretation with maximum respect for Hong Kong's self-contained common law system. However, this does not mean that there are no other possible channels for the purpose of maintaining the one country, two systems. As implied by the Congo case, the participation of relevant central authorities, namely the Ministry of Foreign Affairs, their participation to the constitutional dialogue with the courts of Hong Kong through issuing letters of its opinions on the matter has provided a possibility of developing a framework of constitutional dialogism, engaging various relevant actors in the interpretation of Hong Kong basic law for the maintenance of the one country, two systems on the premise of judicial independence with the final authority of education of Hong Kong courts. And these dialogic channels can facilitate the courts to discern relevant Chinese law issues involved, in particular when some relevant legal issues to Chinese law is ambiguous in the education. And apart from this, NPCSC actually has also developed a dialogic channel to express the meaning of relevant Chinese law issues to relevant to basic law through its internal working and administrative body, that is Legal Affairs Commission, LAC. There's no doubt that the LAC, since its establishment in 1979, has been involved into a primary bureaucracy working for the drafts of NPCSC's legislations, including the interpretation of the basic law with the consultation of the Hong Kong Basic Law Committee. And due to the NPC under CCP's leadership is mostly performing the function of constitutionally procedure endorsement, and its executant, namely the NPCSC, functions as a bureaucracy instead of the democratically deliberative authority as those in liberal democracies. The LAC, as a primary working unit for NPCSC's legislative affairs, is almost functioning like an invisible legislature in China. So LAC's expression of the basic law may be made in at least two different situations. The first is relevant to the NPCSC's formal interpretation of the basic law, either before or after the interpretation for various purposes, for example, providing necessary information to the public or providing a detailed explanation of the interpretation, etc. Right? In this situation, the LAC as an internal agency of the NPCSC truly works for the NPCSC's interpretation of the basic law. Differently, the other situation is that the LAC is not working for NPCSC's formal interpretation, but merely making expression of the basic law in the public by itself. In this regard, due to NPCSC's special constitutional status as authority to interpret Hong Kong basic law, and LAC as NPCSC's internal agency, it is argued that the LAC should refrain from making an expression of the basic law unless the issue involved has been of manifest constitutional significance. And following the principle of subsidiary and the symbolic component of the one country as inherently entailed by the one country, two systems, then it's argued that NPCSC also should take no more than necessary interpretation with maximum respect for Hong Kong's self-contained common law system. Of course, finally, for the purpose of maintaining the one country, two systems. Well, this is the general framework of the constitutional dialogism as normatively argued for the maintenance of the one country, two systems. Yeah, this is my presentation. And thank you very much. And I will be delighted to take any of your questions. And now I would like to hand back to Charles to commence the Q&A session of today's webinar. Thanks.
Well, thank you, Susan, for your very strong and passionate presentation. So next, I will open the floor to the audience to see if there is any question coming through.
So can I raise a question?
Yeah, sure.
Yeah, I'm very much impressed by Shu Cheng's topic. I just want to learn from you that as a layman in the field, so I want to learn something that do you think that whether Hong Kong government could from their side to have some initiative to solve the problem that you described? So it's very layman, so I hope that I can hear some answers from you.
We will first collect all questions. I now respond to the question, Professor Liu Chao.
Yeah, what did you say, Susan?
I mean, shall I respond to the question now? Or...
Yeah, please go ahead. Yes.
Okay. I think the general principle is that the Hong Kong system is self-contained. Anyway, but anyway, there's no guarantee the self-contained common law system always works, as we can understand, because of the huge difference between Hong Kong and mainland China in many aspects. Because of this, if the self-contained common law system does not work, in the sense that something has gone beyond the limits of the autonomy of Hong Kong, I think that will be justification for the one country, the relevant central authorities to take relevant political action, right, in order to maintain the one country, two system. That's my general understanding. Yeah.
Well, okay, thank you, Susan. Now, if there is no other question coming up, then I'd like to thank all the speakers for your efforts and the contribution. And I would also like to thank those and all the colleagues at the UQ Law School, and also Dr. Ensen, Li Ensen, who has basically taken over the majority of responsibility since I left UQ for this conference. So thank you, Ensen, and thank you all the colleagues at the UQ and also at the CTU for contributing to this session. It's my hope that our dialogue, which I find very beneficial and interesting, will continue in the future. Thank you all.